Hello everyone, welcome to Excellence IAS Academy. In this video, we will discuss how Supreme Court or High Court judge is removed from his office. Let us discuss. Before that, discussing how the High Court judge is removed, we will discuss context and his appointment and what are the grounds can be considered to remove High Court judge from his office and what are the provisions exist to remove High Court judge as well. So let us please. Context is that the Vice President recently said that the Parliament only is eligible, means empowered to remove High Court judge from his office. But we'll discuss how the High Court judge is appointed to his office and how he is removed and why the Parliament is only empowered body to remove him from his office. Okay, discuss. Article 217 says that High Court judge is appointed by the President, but after consulting Chief Justice of India and Chief Justice of the concerned High Court. But Chief Justice of the High Court and Chief Justice of India are not only body shall be consulted by the President. Chief Justice of the High Court recommends names to the Supreme Court Collegium, means headed by Chief Justice of India. Not only suggest the name, he is not allowed to suggest names by himself only, but he after consulting two senior most judges of the High Court. Means this is the collegium in High Court. The Chief Justice of India, after consulting the whole collegium, recommends the name to the CJI. CJI again, by consulting two senior most judges in the Supreme Court, means in the collegium, recommends these names to the executive. You know that in the Supreme Court, collegium system consisting of CJI plus 4 senior most judges, right? But in the appointment of the High Court judge, CJI is allowed to consult only 2 senior most judges of the Supreme Court in the collegium. But after recommending the name to the executive, here President, the President can resend those names to the executive again for reconsideration. But if the judiciary again resend those names, in this case, the President is bound to appoint those names to the High Court as a judge. This is appointment with respect to High Court judge. Article 217 says that certain provisions of the Supreme Court with respect to removal, service conditions are also applied to High Court judges. Means Article 124 subclause 4 and subclause 5, which governs the removal of the Supreme Court judges, are also applicable to High Court judges, and because of Article 218. Article 218 says that certain provisions of the Supreme Court are applicable to High Court judges as well. So because of this Article 218, Article 124 subclause 4 and Article 124 subclause 5 are also applicable to High Court judge for the removal from the office. So, but what Article 124 and Article 124 subclause 5 says? Article 124 subclause 4 and 5 says that the Supreme Court judge can be removed from the office on 2 grounds. One is incapacity, another one is misbehavior. These 2 grounds can be considered to remove from the Supreme Court judge from his office. So these 2 grounds also applicable to High Court judge as well, right? And this 124 subclause 4 and 5 also says that the Supreme Court judge only can be removed by the Parliament if the both houses of the Parliament passes resolution with a special majority. What is special majority here? Special majority is a majority of the total membership, of total strength, right? In the case of 223 in the case of Lok Sabha, right? It is the majority of the total membership of the house. And also special majority is 2/3 majority of the present and voting. So this is become special majority. If both houses of the Parliament passes the resolution for the removal of the Supreme Court judge with special majority, then President removes the Supreme Court judge. So this procedure also applicable to High Court judge under Article 218 and Article 124 subclass 4 and 5. But we also enacted Judges Enquiry Act in 1968, which governs the removal of the High Court judge and Supreme Court judge. Under this Judges Enquiry Act, it is laid down procedure to remove the Supreme Court and High Court judge. What is the procedure? Both the houses, in the case of removal of the High Court judge or Supreme Court, Lok Sabha as well as Rajya Sabha. Lok Sabha and Rajya Sabha. In case of Lok Sabha, 100 members sign motion, and they will give to Speaker of the Lok Sabha. Speaker of the Lok Sabha. In the case of Rajya Sabha, 50 members of the Rajya Sabha sign a motion and give it to Chairman of the Rajya Sabha. Here, Speaker and Chairman both have a discretionary power, whether they can admit the motion or dismiss the motion. If both dismiss the motion, here proceed become ends. Means there is no further discussion or any further procedure with respect to removal of the High Court judge, Supreme Court judge. If Speaker and both Chairman admits the motion, then they will form a committee, 3-member committee consisting of CJI or Supreme Court judge, Chief Justice of the High Court, as well as distinguished jurist. This 3-member committee will inquire into the allegations made by the members and will submit report to the Speaker. If the 3-member committee found guilty of Supreme Court or High Court judge of conducting any misbehavior or incapacity, then Speaker put the report in the House, as well as Chairman put the report in the House for the discussion. The discussion goes on in the Parliament, in both houses. If it's originated in the Lok Sabha, it happens in the Lok Sabha. If it originated in the Rajya Sabha, discussion happens in Rajya Sabha. So, if discussion happens in the Lok Sabha passes the resolution with special majority. We already discussed what is special majority, and will be forwarded to the Rajya Sabha. And Rajya Sabha also should passes the bill with a special majority of the total membership of the House and 2/3 members of the present and voting. If both houses passes the resolution with special majority, then it will send to President, and President is bound to remove the High Court judge or Supreme Court judge from his office. This is procedure laid down in the Judges Enquiry Act of 1968. Thank you for watching the video.